Welcome, everybody. Hopefully, we've got everybody just coming online at the moment. My name is Belinda Honey. I'm the Chief Workplace Strategist for Mapien, based in Perth, but my role is a national role. And today, our panellists come from across the country. We've got Sarah Pettit, who I'll introduce in more detail a bit later, who's in our Perth office, who's our Chief Migration Agent. We've got Jamie Patterson, who's our Head of Workplace Strategy for our Southern region, who's based in Melbourne. Leith Middleton, Dr. Leith Middleton, who's our Specialist Group Lead for Psychological Health and Safety, who's based in Brisbane, and Alex Aspromodis, who's our Chief Industrial Relations Strategist, also based in Brisbane. So welcome to everybody. It's definitely a national webinar today. We've got hundreds of people spread right across the country from many different industries. So really interesting to see our client base coming together. Mapien, year on year, we tend to have about 700 to 800 clients from many industries across Australia. So great to have many representatives of our clients across Australia. We conduct these webinars at the end of every year, specifically to talk about, well, what's been keeping companies busy this year? What has our team been working with our clients on? And this year's been an extremely busy year. A couple of weeks ago, I was at a conference and I was asked to talk about, the pressures and the stresses on HR professionals at the moment. And I said that in the 35 years of my career, I don't think I've ever known a period where employers, HR professionals and leaders are having to deal with so many different aspects of the people at workspace. Everything from immigration to industrial relations, psychological health and safety, payroll compliance. It's just a hotbed of issues at the moment. Unlikely to be any change in 2025. In the midst of that, we've also got an election happening, which could potentially result in even more changes, regardless of who wins that election. So over the last few weeks, there's just constant headlines in this area. The first area we're going to be discussing today is industrial relations. And obviously there's been huge changes in industrial relations over the last couple of years, and Alex will be sharing the impacts of some of those changes. Recently, there was a headline only in the last few days in The Australian saying, but wait, there's more IR pain. And I read it and thought, what? And then had a look, and it resulted from the IR Minister Murray Watt saying that Labor would take a second round of workplace changes to next year's election, and they will not change the current laws, so there won't be any changes to what they've already put in place. We can also expect changes as well if there's a coalition government, because they've made it very clear that they will be examining all the changes that have been made. So industrial relations is going to be another hot topic in 2025. Immigration, who knows what? Lucky we've got Sarah Pettit with us today. Who knows what's going on in that space? It's turned into a political issue, obviously, with an election coming up in 2025. Just this week in the Australian Financial Review, headline, Dutton vows deeper cuts to student enrolments and migration numbers, specifically talked about migration in respect to student enrolments, student at universities and the impacts on the housing shortage. So he's setting up for an election well and truly. So Sarah will take us through some of those areas. Psychological health and safety, that's another area that's, a lot of positive things happening in that space. I think we can say that without a doubt. But there is also a lot happening. And, even in the last few weeks, there's been 3 new risks have been included in the updated National Psychosocial Code of Practice. So just another area for employers to get their heads around. But Dr. Leith Middleton will take us through some of that and also give us some of the positive things that are happening in that area as well. And then lastly, in the general people at work space, there's just stuff happening. I mean, the issues around return to work continue to be a problem. I know even every day, just about, I'm speaking to employers about how they're managing some of these issues. right to disconnect, flexibility, etc., etc. You know, and the Australian Financial Review, very recent headline again, the Commonwealth Bank has threatened to cut bonuses in return to work push. There's a number of large employers now that are saying if you don't return to work as required under the company policy, there will be impact on people's bonuses. And even in the conference I was at a couple of weeks ago, there were a number of employers talking about how they've implemented some of those arrangements as well. So there's a lot happening, a bit of a hot topic, all of these areas at the moment. So as we go through everything, there's the opportunity for all of you to ask questions. Please ask them in the question and answer box. We have Joanna Berry, one of our industrial relations consultants in our Brisbane office, who is going to monitor those questions and help me to ask the questions along the way. So please ask them in the question and answer box. If we don't get through all of your questions today, and I've got some questions for the panelists too, if we don't get through them all today, someone from the team will definitely get back to you with a response to your question later on. So let's get started. What we're going to do, the way we're going to do this today is each of the panelists are going to talk to us for a few minutes, up to about 5 minutes, about their particular area and what's been happening in 2024. And then we'll go to some questions, and then later on we'll talk about 2025. So let's start with Alex. Industrial relations, Alex. What a minefield. You know, someone like you who's been in industrial relations even longer than me, you know, you must agree that we haven't seen the level of changes that we've been seeing in the last few years since the Fair Work Act got implemented. What's been happening in 2024 from your perspective, in your team's perspective, and what have employers been having to grapple with?
Well, I think just to kind of reiterate, Belinda, what you said up front, I mean, there's certainly a sense amongst all my clients of IR change, kind of overload and fatigue, or probably exhaustion. And it's not surprising, given since the Labor government came to power in 2022, there's been 28 major changes to the industrial relation legislation. So if you kind of step back before this year into kind of December 2022, the secure jobs, better pay changes kind of came through. And so that introduced prohibitions on pay secrecy, restrictions on the use of fixed term contracts, prohibition on job advertisements contravening the Fair Work Act, and the introduction of an ability for the Fair Work Commission to resolve disputes around flexible working arrangements, as well as the introduction of paid family domestic violence leave. Moving then into 2023, we have closing the loopholes #1. We got closing the loopholes #2 this year, but last year came in December of 2023. Closing the loopholes #1 introduced the concepts of workplace delegates' rights, same job, same pay for labour hire employees, prohibition of discrimination for employees experiencing domestic family violence, changes to enterprise bargaining rules around a variety of things, including protected action ballots, criminalisation of wage theft, termination of zombie collective agreements. The list kind of goes on and on. So that brings us to this year, 2024, which we have another tranche of significant changes coming through. So in February, there was increases in penalties and new penalties for time and wages breaches. There was more changes to the enterprise bargaining regime, particularly around the introduction of intractable bargaining determinations. So where you can't reach agreement, there's an ability for the Commission to come in and arbitrate, but also with a context that the outcome can't be any less favourable to employees than what their current enterprise agreement provides. We've also got transitioning from multi-employer agreements. We've got franchisees being able to do single enterprise agreements. The list goes on. July 24, workplace delegates' rights clauses are included in awards and enterprise agreements. Right of entry requirements for unions investigating underpayments was loosened. 26 August 2024, kind of the most recent kind of round of significant changes. We've got changed definition of casual employees. We've got casual employees' requests for full-time, part-time employment subject to review by the Fair Work Commission. So we can't just say no anymore. And changes to definition of employer and employee in the context of engagement of independent contractors, minimum standards for gig economy workers, minimum standards for contractors, road transport industry, right to disconnect, unfair contracts regime to review the terms and conditions of independent contractors. And then 1st of November, same job, same pay orders commence operation. So over that kind of December 2022 to now, what we've really witnessed is the federal government's implementation of a series of changes, designed to create the kind of, ideal utopia, Labor, inverted commas, kind of workplace. And so what does that workplace look like? It probably doesn't look like anything like our workplaces. So, what it is all workers are employees. There's no independent contractors because there's no point in engaging independent contractors. All our employees are full-time or part-time. We don't have casual employees. And those employees kind of get to pick and choose the hours they work through the variety of flexible work arrangements that are in place. All our employees are covered by an enterprise agreement. So the awards there are really a safety net, but everyone's covered by an enterprise agreement because the regime kind of, forces us down that enterprise bargaining regime. And obviously those enterprise agreements are all negotiated by unions. All our employees are union members enjoying the fruits of the labour of the union movement. And for those small number of workplaces that still think it's a good idea to have labour hire employees, all those labour hire employees are engaged under effectively the terms of our enterprise agreement through the same job, same pay regime. And so, that's the goal for what the legislation is trying to achieve. Now, it hasn't got there yet, but it is starting to head in that direction. So essentially what the government has done over the course of their process and timeline is that they've introduced all the conditions that unions have been trying to negotiate an enterprise agreement for years and years and years and have been unsuccessful in doing so. And so to kind of cut out the employers out of the whole arrangement, we just legislate it. So we will legislate delegates' rights. We will legislate paid union training leave. We will legislate same job, same pay rates for labour hire employees. As unions, we want a permanent, secure employment for all employees, and we want the workforces to be decasualised. We don't want independent contractors. We want minimum conditions for gig economy workers. We want wage theft. And even that term kind of, grates on me because we all know that employers work very, very hard in paying people right. And sometimes for a whole variety of reasons, we get it wrong, but that's not theft, right? Theft is intentional. But the use of that term is something which they've promoted very, very heavily. And then you've got this process of if your EBA is expired anytime within the last 5 years, then you can be forced to renegotiate it. And effectively what that means is if you've got an EBA now, you'll have an EBA forever. And if you go through a process and you can't negotiate the EBA, then they'll get an intractable bargaining kind of order, and the Fair Work Commission will ultimately come in and impose an outcome upon you. And the way the rules are currently set up is that outcome cannot be any less than what employees currently receive. So there's no capacity for an employer who makes a bad deal to ever claw back those conditions. And that's a really concerning thing because it changes the balance of power in that bargaining framework. So we've got a federal election next year, 2025. Only time will tell whether we'll soon have to go through another raft of changes in the IR space. I note Belinda's comments about what Murray Watt said, that there's more coming. Please, no more from Labor. If there is a change of government, clearly there will be changes. Dutton has been a little bit quiet about what those changes will be, but certainly those areas that they perceive as extreme will be altered and kind of, they'll probably revert back to what it was previously. But while there may be more change coming either way, if there is a Liberal government, the change may be more pleasant than what we've endured over the last 2 years. So that's it for me.
Thanks, Alex. Yeah, it's a complicated area. There's a lot for employers to be grappling with just in the IR space at the moment. Okay, we'll continue to move through before we get into the questions. Sarah, what is going on in the immigration space? I mean, normally industrial relations is front and centre in terms of the political discourse in this country, but now it's immigration's at the top of the list. What's happening?
Yeah, thanks, Belinda, and thank you, Alex. So it's been a massive year for migration changes across all programs, but I guess positive ones for the most part. Communication has been fairly quiet from the Department of Home Affairs leading up to the delivery of the Skills in Demand visa, which we're waiting with bated breath for. I had the pleasure of emceeing the Migration Institutes of Australia's conference in Brisbane a few weeks ago, and my whole team nationally attended the conference, where we heard on day 2 from the director of the Skill Migration Program, and he confirmed a few things for us. I asked him a few questions, and hopefully he will, Santa Claus will bring us some good news before we break for Christmas. But I wanted to, I guess, just go and have a look over the last 12 months. There have been quite a number of changes. So today I'm just going to focus on the changes to the employer-sponsored visa program, which again have been quite positive and ones we've been waiting for. And the department have, I guess, kept up their end of the deal in making these changes, especially based on the announcements from Claire O'Neill back in March and April 2023. So we'll go through and have a look at what's actually changed, and then I'll take you through some information in respect of what's coming in December for the Skills in Demand visa. So throughout this year, we've had the TSMIT increase, so the temporary skill migration income threshold, after I think 13 years of it sitting at 53,900 as a base rate of pay to sponsor any overseas worker. It moved up to 73,150 base rate of pay, and that will be indexed annually. That did quite cause a bit of fuss for some employers, especially perhaps where they might be working in the hospitality sector where they might be paid below the 73,000. I think that has settled down now. We had some changes to the labour market testing requirements. So we've had the removal of the mandatory Workforce Australia platform, which was great news and welcome news, because it was a really difficult platform for employers to navigate and even just log into, with all the different ID checks that needed to happen to post an advert. We had the introduction of the West Australian DAMA, which was great and really well received. We had major changes on the 1st of July to the 482 visa conditions, the 8607 condition, whereby previously, prior to 1 July, individuals, if they ceased employment with their sponsoring employer, they had 60 days to leave the country or find a more suitable employer to support their application. So what the department have changed now is that the visa holder has 180 days once they've ceased employment. They don't have to wait for the nomination application transfer to happen with the new employer. They can commence work immediately with that employer, and they can also work in any occupation while they're seeking a new employer, which is extremely generous. So it'll be interesting to see how that pans out over the next few months as well. We then had changes to the employer nomination scheme permanent visa, so the temporary residency pathway, which is that pathway where the individual has spent a specific amount of time with you on their 482. Prior to the change that's currently in place, the requirement was that 482 visa holder worked for you, the sponsoring employer, for a 3-year period in the last 4. That was reduced to 2 in the last 3, and that was a really welcome change. That really opened up some major pathways for individuals who'd been here for quite some time on their 482 visas. We also saw the introduction of the new migrant worker protections and the workplace justice visa on the back of the Nixon review, and we had the pleasure of hearing from Mrs. Nixon herself at the conference, talking through her recommendations and her insights in that document. Employer sanctions have been strengthened, and I'll talk about those later today as well. And more recently, and I think what's probably most impactful, especially leading up to the Christmas period, is the slowdown in processing of the 482 visas. And I don't know, for those of you who are online and who perhaps lodge your own visas or work with us to support you with the applications, but we've seen a massive blowout in processing times, even for accredited sponsors. From the horse's mouth at the conference, they're focusing on applications where the roles are based in regional Australia. That is a priority for the department right now, with accredited sponsors being, I think, third or fourth down the rung. We got some really interesting stats from the director while we were at the conference. There was over 40,000 482 applications lodged in the last quarter from July to September, with 34,000 being approved in that period. And we would expect the last quarter of this year to have very high lodgements, considering the changes to the occupation list and the introduction of the skill in demand visa. Now, that's just a small summary of the changes. There's been heaps more around students and other factors, but if Belinda will allow me one more minute just to talk about the skills in demand visa. So this will be introduced in December. The program director did not confirm a date, even though I did press, but it is the last fortnight sitting of Parliament, and we're hoping that the date for the SID, skills in demand, should be decided in the next fortnight. What we know is that the subclass will remain the same, so it'll still be a 482, which is great, but instead of calling it the temporary skills shortage visa, the TSS, it will now be called the skills in demand subclass 482. There'll be 3 tiers under the skills in demand. Tier 1 and Tier 2 will target specialist skills and core skills. So Tier 1 being your specialist skills, including highly skilled migrants and any occupation except for trades, machine operators, drivers, labourers, and the salary must be at least 135,000 base per annum. And then our Tier 2 will cover the core skills group, and that's for skilled employees for now and for the future to help Australia with the skills shortages. And there will be a new core skilled occupation list released called a CSOL. Now, that's not your garden fertilizer, so don't get confused, but the skills income threshold for that will be TSMIT to 135,000 per annum as well. Tier 3 has not yet been developed, but that will be called the labour agreement stream, where we'll see aged care, childcare, manufacture, processing, and other agreements fall under this tier. And this will work in tandem with the specialist and core skills stream. And on Saturday, we have a change to the 482 work experience policy. It'll be reduced from 2 years in the last 5 to 1 year, which is great to see. And on the 6th of December, ANSCO will be changing from OSCA, and we're separating Australia and New Zealand, and we will have the occupation standard classification list. This is a modernised occupation classification system, which will better align with Australia's labour market needs. And that's it in a nutshell for now.
So a lot of things happening, and
yes,
some of them quite positive. Yeah. Okay, thanks, Sarah. All right, let's move on to Leith. Your area, Leith, obviously you've got a national focus in the area of psychological health and safety. And, you know, while there's a lot happening and a lot for employers to get their heads around, there's also some really positive things happening as well. So what have you seen in 2024 in your area?
Yeah, great. Thanks, Belinda, and hi everyone on the webinar today. I think everyone will probably be broadly across this topic now. Mostly, I guess, a lot of the shifts in 2024 have been related to the, you know, the workplace health and safety legislation and the codes of practice. And I think that has been mostly driving momentum in 2024. But I also think just that push to have mentally healthy workplaces is still really important for a lot of workplaces in this discussion. And I think that's a really important one to firstly say that I think that's an area that should be still in the forefront of people's minds, is how are we just having mentally healthy workplaces for people to work, as opposed to this just turning into a compliance exercise. We've definitely seen, I think, just from all of our work in this area and just sort of the surveillance that we keep across in terms of all of the regulators, that there has been, you know, the legislation has been widely socialised within Australian workplaces in 2024. So I think we've really gone from a lot of workplaces not knowing much about what this even is, to a lot of workplaces being really across it. So the message has been heard loud and clear. And I think I've certainly noticed that many states have moved, or many organisations have moved from sort of speaking about mental health and about that being important to actually really digging deeper now to kind of comprehend, you know, what is it about our workplace? What is it about our workplace factors that are impacting on people's well-being and mental health? So there is I think, a push to really look a bit more deeply at this topic and to see it more as a workplace issue. So if there's anyone out there on the call who's thinking, what is this, you know, legislation, and we haven't done much, then that would be a little bit concerning to me, I think now. I think most organisations are across this. I think also what we've seen, though, in 2024 is this inevitable collision with some of the psychosocial type aspects, which are falling into HR and IR spaces. And I think because of the work that we do at Mapien, which is often very interdisciplinary, we're starting to see a real you know, the psychosocial hazards and factors and language coming up in lots of different, you know, workplace investigations, even in Fair Work findings, and also being raised in enterprise bargaining as well. So it's certainly something to keep a lens on, that these areas are naturally having a bit of a collision, and I think that will continue to accelerate. We're seeing lots of shifts in communications with regulators across Australia. Definitely Safe Work Australia, if you're not already keeping up with what they're publishing in this space, it's definitely an area you want to follow. And it's all, they publish some really great sort of surveillance data, some psychosocial statistics that I think are really helpful in this space. And also all of the regulators across Australia are publishing and providing information in this area, but probably the leader in this area at the moment is, just from my observations, is probably Safe Work New South Wales. And I think we can expect that the rest of the country will follow with some of the things that they're pushing out in terms of the work that they're doing. So they now have a 5-year strategic plan. And also I think it's clear that the regulators are really getting their ducks in a row to really ramp up regulation in this area as well. So I think we're definitely seeing an increase in maturity across organisations in relation to this space, and a deeper level of intervention. And some of the key activities, I guess, I've heard about that organisations are doing or been involved in and supporting our clients are things like psychosocial governance, training and development, of course, is a very popular area. A lot of work done by a lot of organisations about how to better include these in their workplace health and safety metrics. So that seems to be an area that organisations are really working on, is how do we better incorporate psychosocial in our workplace health and safety metrics and data collection. And also a lot more risk assessments being done across different workplaces, and sort of mental health awareness as well has continued. So the only thing I'll just comment on before I stop is just, Belinda already mentioned that there has been a change in the National Code of Practice. And this is something just to be aware of. It's very recent, but there's basically 3 new hazards that have been added to the National Code of Practice. And these are fatigue, intrusive surveillance, and job insecurity. So I think these ones are going to be kind of interesting ones to watch, and potentially there's a bit of controversy in some of those as well. So thanks, Belinda. I'll stop now.
Thanks, Leith. We'll get back to you in a minute with some questions, no doubt. Lastly, Jamie, your team in the workplace strategy space, you're quite on the ground and very connected with people working in people and culture HR teams, and you've been supporting them in a lot of areas. Fill us in on what's been happening in 2024.
Yeah, thanks, Belinda. Thanks, team. There is a lot going on in all areas of employment, but there's 3 areas that I want to touch on. And the first one is right to disconnect. So this concept was announced in sort of February 2024. It wasn't on the ALP's agenda originally. It was put on there by the Greens, but when it did make it on the agenda, they said that they would consult with industry. Unfortunately, they didn't. It just dropped in February, and sort of industry was quite up in arms about this. They did it at the time because they needed to make a deal with something, get something through the government, and they needed the Green support on that. So it was dropped in 2024, in February 2024, with limited, if almost none or no consultation with industry. The legislation came in effect in August 2024 for large employers. For small employees, you've got another year till August 2025. It's getting a lot of airtime from our clients this year, from requests to draft policies, to run training, to amend contracts, and even dealing with some employees who are playing the right to disconnect card. So for those not familiar, the right to disconnect essentially gives employees the workplace right to refuse to monitor, read, or respond to contact or attempts to contact outside of working hours. It's now embedded in the modern awards, and disputes can be heard by the Fair Work Commission with stop orders being issued. And the other note is that it's not impacted by the high income threshold or non-award covered employees. It applies to everyone. It's scary for some employers, but ultimately it does not mean you can't contact your employees outside of working hours, as long as that contact is reasonable, and employees can refuse if that response or if that refusal is reasonable as well. Ultimately, this is something that can be dealt with through some clear communications, accurate drafting of wording in contracts of employment that reflect the employer's expectations. So where people are required to be on call, where people are required to attend meetings late at night because they work for international companies, etc., or they're paid accordingly. It just needs to get addressed in contracts of employment, and some better workplace practices around some email tags. If you're sending emails at night, a message at the bottom saying that, I don't expect you to respond to this, or timed emails as well. Where it might get tricky is that employers need to be conscious that of adverse action. So this can be brought against employers where the employee has a workplace right and they've exercised that workplace right, in this case, the right to disconnect. So it's really important that no commentary or decisions around performance or promotion involve someone's exercising their right to disconnect, involve someone not responding to late night calls or weekend calls. Hasn't really been tested yet, but we'll see how we go in 2025. Respect at work is the second thing I want to talk about. So it dovetails very nicely into what Leith Middleton was talking about before. It was born out of a report that was commissioned by the previous federal government, conducted by Kate Jenkins, who was the then Sex Discrimination Commissioner. The report was known as the Respect at Work Sexual Harassment National Inquiry Report, and it was damning on Australian workplaces. And what resulted from that was essentially the need to address sexual harassment and discrimination and sex-based harassment in the workplace. With one key aspect of that, or a key aspect of that, was the implementation of a positive duty on employers to take all reasonable steps to eliminate workplace sexual harassment. Why is it an issue in 2024? It's simply due to the fact that we do a lot of workplace investigations, and a lot of those investigations involve overt sexual harassment. So the message just doesn't seem to be getting through. When we run those investigations, we ask employers about what have you put in place? What are you doing about this? And often the response is, we've got policies in place, we've got an EAP for employees, and we run bullying and harassment training as part of our induction. When viewed against the hierarchy of controls in the OH&S world, these items are really good administrative controls, but they do fall short of the engineering controls and ultimately the elimination. So from what I've seen is employers are doing something, but they're just not doing enough in that area. So what do they need to do? They need to do the EAP, they need to put in policies and procedures, and they need to run training, but they need to also think beyond the administrative controls and put in some engineering controls, such as provide confidential avenues for employees to raise their issues, so whistleblower type hotlines, collect and monitor employee data through engagement surveys and spot surveys, promote stop the job conversations when it comes to witnessing sexual harassment. And I think they need to start holding people to account, people managers and bystanders as well. And they hold them to account through policy and through action as well. And the third part I want to talk about is award compliance. It's still ongoing, so continues to be an ongoing concern for employers. We work with a lot of organisations that just struggle to interpret the awards and the employment instruments that they're on, and they end up in disputes with employers, with third parties, and sometimes in front of the Fair Work Ombudsman with a big please explain. Look, there's no doubt, and Alex touched on this, there's less scrupulous employers out there, but from our experience, the companies that come to us, they just want to be doing the right thing. The employment system is complex, which is evident by the amount of people that get it wrong. So it's commonplace for them to come to us and seek some assistance over the last year. And what that sees us doing is payroll audits, where you have a look at a percentage of the workforce, a couple of pay runs, hopefully including a public holiday. We look at what they should have been paid, what they did get paid, and it allows us to present back to our clients on, where your underpayments are, where your overpayments are, and also any themes that are coming up. So, what employers need to do in this space is they need to make sure they're interpreting employment instruments correctly. They need to make sure that their pay rules are built into their systems well and in a robust way, and they need to monitor and keep an eye on any employment instruments, any modern awards, and any changes that come through to them. So that's the three areas that I've got, Belinda.
Great, thanks, Jamie. Well, there's been a lot provided in the last 25 minutes in terms of some of the key areas from an employment perspective that our team nationally has been seeing. Joe, I might move to you to see if we've got any questions, if we can move straight into the questions and see what we've got from the audience.
Yeah, of course. A couple have been answered by Alex, but I've got two that I believe are for you, Leith. So the first one is, do you know more about the new workplace sexual harassment regulations in September 25?
No, I don't. Jamie might. I know that there's going to be a requirement, though, that from March next year, all workplaces will need a sexual harassment action plan, but I don't know anything more about anything beyond that.
That's probably the extent of my understanding as well, Leith. Joe.
Thanks, guys.
We'll come back to you with more information about that one. We'll take that one on notice.
Perfect. And then there was just more about, I just wanted to reiterate the 3 new psychosocial hazards. And does this mean that the PCOP has been amended?
Yeah, look, that's an interesting question. And I think because of the newness of it, even I'm sort of still doing some investigations and research around it. Basically, I saw it come up, and the 3 hazards were fatigue, intrusive surveillance, and job insecurity. Basically, the best place to have a look, because there's quite a lot of background information on the Safe Work Australia website in regards to this and in regards to those 3 hazards. It has been added to their code of practice. So yeah, whether that means it's going to flow down to state codes of practice, I'm not sure at the moment. But yeah, I definitely encourage people. It's easily able to be found on the Safe Work Australia website, and there's quite a lot of information about those 3 new hazards as well, and their inclusion in the code of practice.
Okay. Thanks, Leith. Joe, anything else?
They're all the ones that we have now, so maybe moving to yours.
All right, thanks, Joe. So we'll start moving to some questions that I've got for the panel. Alex, I might start with you. Obviously, with these changes in enterprise bargaining and also the changes in the dynamics of what's happening in this space. In respect to the enterprise bargaining space, Have you seen some changes in unions and employee representatives and when you're actually negotiating any enterprise agreements, particularly you who negotiates really big enterprise agreements as well?
Yeah, Belinda, there's certainly been a change of approach in that the regular kind of claims that you ordinarily see, a lot of that is not coming through because some of it's already been dealt with legislatively. So what we kind of have seen is this emergence of a new kind of group of kind of, aspirational type claims or conditioning claims. So claims they don't necessarily expect to get this time round, but that they will more seriously pursue next time and probably really want to get the 2 EBAs. So those kind of more sophisticated unions, when they're bargaining, they're not just bargaining for this EBA, they're bargaining for 1 or 2 EBAs in the future. So some of the stuff that we're starting to see is particularly around, the paid family leave space. So there's the obvious one to make paid parental leave available for both parents. It's about extending the period. It's about combining it with the government's paid scheme. Then it's about adding superannuation onto those sorts of payments as well, and to fill that sort of gap, which has been a significant issue for the union movement, in which the government has announced they are going to start to fill that void. I think next year they're looking to commence payment of superannuation contributions on the government's paid parental leave payments. And so there's pressures from that to come into EBAs. Generally, what we're seeing is EBA increases are arcing down. That's not surprising because of the changes in the CPI, but there is been I guess there's a delay in that realisation coming across the unions and also their members, because they are saying things like, well, over the life of the last agreement, I've lost 5%. I want a 5% catch-up payment. So there's a lot of requests for catch-ups. And of course, they only ever want to catch up when they're behind, never when they've been ahead for the previous 3 or 4 EBAs. So that's kind of what we're seeing. They are bargaining harder because they think they have more tools in the kind of tool shed now with the changes in legislation. Something which hasn't been commented on, and it's an underlying issue, I just kind of flag it here, is that the federal government have termed what they've termed a rebalancing of the Fair Work Commission. So the rebalancing of the Fair Work Commission means they put in place a number of new deputy presidents and commissioners, etc., that have come from a strong union background. And so what we're finding is that we're dealing with not just new commissioners, but commissioners that have a particular perspective on issues. And I'm not suggesting that any of those commissioners are biased or anything like that, but they just look at the world differently. And you need to take that into account when you're appearing before those members. And you need to adopt and adapt the way that you present. But I also think that is giving the unions an underlying confidence that if they get into a fight, they're going to get into the commission, they'll have one of their old buddies determining it, and that's more likely to be favourable to them.
Okay. And just before I move on, in respect to same job, same pay, obviously there's been a lot of applications in this space. I know the Mine Workers Union is just lobbing applications in practically every week. Do you think this will start to die down, or do you see it continuing?
Well, the actual orders only commence operation on the 1st of this month. So that crystallisation and now the impact that those successful applications have had, and most of those applications have not been opposed. So most employers have seen the writing on the wall. They really can't stop it. So they've just let it go through. Now that's resulted in, they've said, some huge increases to those labour hire employees of up to $50,000 a year. So the gains to the union movement as a result of that are significant. That is obviously going to push a basis for them to recruit. So in those highly unionised blue-collar workforces, it's just inevitable that it will continue. Whether it will then translate into those workplaces where the differential between labour hire and directly engaged employees is not as great. And I'm thinking, areas that I work in, like, hospitality, tourism, those sorts of areas, they use a lot of labour hire as well, but the margin difference is not as significant, and therefore the incentive to seek those same job, same pay orders are likely to be less. The other outcome that I can perceive with it is, well, if the labour hire employees are being paid the same as our employees, and then we're paying a margin on top, why are we doing this? Which is probably really the long-term goal of both the government and the unions, is to get all these labour hire employees as directly engaged within organisations. And I suspect that there will be some financial pressure to directly engage previous labour hire employees in the future, particularly if the Labor government remains in power. If they don't remain in power and there's a change of government, then you could see a change to some of these rules.
Yeah. Okay. Thanks, Alex. Sarah, we'll move on to you now. So you talk to us about the skills in demand visa. So how does the implementation of that visa impact existing subclass 482 visa holders?
Good question. Thank you, Belinda. So existing 482 visa holders will be able to continue to hold their 482 until such time as they need to reapply to renew that visa. If at that point in time the skills in demand is in effect, then that employee holding the 482 visa will be applying for a skills in demand 482 application. The occupation list is changing as well once the skills in demand list has skills in demand visa has been introduced. So what we've been advising clients over the last few months is that if you're concerned that the occupation has been flagged for removal on the JSA's website, they have provided 3 occupation lists: a confident off list, a confident on list, and a list for consultation. If your employee's occupation is on that confident off list, I'd be shaking a leg now and looking to lodge a new 482 before the skills in demand comes into effect in the coming weeks. If they have an occupation on the draft consultation list and you are concerned that that is going to be removed, again, I'd be looking at lodging a new 482 now, just to ensure you can extend that employee's period. If the occupation is removed and it is gone by the time you look to renew the application, you're going to need to reach out to your migration agent, Mapien, to have a chat about how we work through that process. However, there will be some transitional arrangements in place for those wanting to progress to permanent residency, like the ones we had in 2017 when the department turned the 457 program on its head and introduced the 482 migration program, which is what we're dealing with today. So there will be some transitional arrangements in place. What those look like, we're not sure. Word on the street is that there will be some changes to the 186 employer nomination program as well over the coming months. Hopefully those will be a bit more relaxed and streamlined as well, and not too cumbersome. But yeah, lots of up in the air and unknown at the moment, Belinda, unfortunately. And I think, you know, we may only get a day or two notice as to when the skills in demand visa is going to be implemented and what that occupation list actually looks like. So we will do a webinar and a client alert as soon as we have that information, so we can keep you all up to date on those changes and how they will impact you, if any.
And just for everybody's interest, you know, what are the top occupations and nationalities that are being granted in the TSS 482?
Just happen to have a fresh list here, so what a great question. So while we were at the conference a few weeks ago, again, the director from the Department of Home Affairs did share some really great slides with us in respect of the permanent skill migration program and the temporary skill. So I've got some stats here from the temporary skill, the TSS migration program. So the top 10 occupations for the 23-24 program year were RMO, so resident medical officer, chef, software engineer, motor mechanic, diesel motor mechanic, not a surprise, ICT business analyst, mechanical engineering technician, fitter, and cafe or restaurant manager. And then the top 10 nationalities for those occupations in the 23-24 program year were India, Philippines, UK, South Africa, Ireland, Sri Lanka, China, Nepal, US, and Zimbabwe. So again, those top 5, no surprise. We process hundreds of visas every month. So that's definitely on point and on trend.
Great. Okay. Thanks, Sarah. Leith, your turn. So we have talked about some of the positive things that are happening in your area. So give us some of the activities that have made workplaces successful in the area of psych health and safety today. What are you seeing that's working?
Yeah, and this is probably a question that I get asked a lot about from our clients as well, because I guess they're sort of wondering what are other people doing and how can we learn from other people's approaches, especially because it's an area that's quite new for most organizations. And I think probably the things that I've seen workplaces do most effectively just over the last 12 months is probably workplaces where they've taken kind of a calm and considered and also a strategic approach. So really not trying to just jump in and sort of troubleshoot, but to sort of sit back and think about how do we implement this in a way that's thoughtful and considered, because I think there has been a little bit of sort of panic around this area, or a little bit of, oh my gosh, we don't have all the things we need to have up and running. And so really the organizations I think that are doing this most effectively are taking a sort of I've got a bit of a saying actually that I stole from my daughter's athletics coach, which is evolution, not revolution. And I think that's a great way of thinking about this space, is it's about building your organization's maturity and not trying to kind of do everything all at once, and being really deliberate about it. So some of the things that organizations have been doing, I guess, is kind of trying to get across key people in terms of training and development and familiarization with what this even is. So particularly up to that senior leader, even board level, around what is this? What are we trying to do? And starting to really educate workplace health and safety professionals, people and culture, HR, within organizations about this. Because I think there's an assumption that those folks will know about what this is and what this means, but as a general rule, that's not necessarily the case. So I think educating people has been something that some organizations have done quite well. Also, the organizations that have really done well in this space, I think, is looking at their current infrastructure. So what have we got? What are we doing well? And doing a bit of a gap analysis. And we've done quite a few of those for clients over the last year, where it's actually helping them to look at, from an external bird's eye perspective, what have you got? What are you doing in this space? And then where do you need to build your maturity? And sort of mapping that against sort of some best practice models now as well. But also I've seen a trend towards organizations starting to focus in on hotspot areas. And I think that's really smart, because if you're trying to do all of this for everybody, that's going to be pretty challenging. So I think organizations that are doing this well are starting to look at, well, do we have any hotspot areas? So that might be, for example, roles where we know there's inherent risk in what they do, for example, or it could be things like, we know, for example, younger workers as a general rule are more at risk in this space as well. So really trying to do that scan. You might have some lead indicators from your engagement surveys and things like that to really get an idea about who do we need to focus on in this space. I could talk for ages, but I'll stop there, Linda.
Exactly. And because I was going to say at the beginning of this webinar, we could sit here for a week talking about everything, but today we're just trying to zone in on a few areas. So thanks, Lee. Jamie, in respect to in relation to award and agreement compliance, give the listeners a bit of a understanding of what you think or what you've seen are the top 3 things that employers are still getting wrong.
Yeah, okay. Good question. Top 3. So I think the first one is classifying your people correctly. If you classify people according to an award and you classify them incorrectly, you can have the most accurate time and attendance and pay rules set up in your system. But if they're classified incorrectly, you're going to be paying them incorrectly. So award classifications under the awards is the first point. Second point, check your interpretation. Just bounce it past someone and make sure that what you think is the interpretation around hourly rates, ordinary hours, overtime, penalty rates, etc. Make sure it's accurate. and then monitor the awards as well. The award rates go up every 1 July, but there's always other little increases and little changes that get dropped into the awards, and we've talked about some of those today. So just keep an eye on the award or your instrument and how it's moving, and even the the allowances. Sometimes allowances jump up, and there's little communication about it. So just keep an eye on all that.
Yeah, and of course the other area being the people are on salaries. So an assumption that because they're paid above the award or the enterprise agreement that it's all okay, and then you get caught out with allowances that can't be absorbed into the salary and things like that. So yeah, don't presume that if you've got a salary that all's okay.
Yeah.
We've only got 5 minutes left. Like we said, we could speak about this for hours. I'm going to go back to the panelists. You've got between 30 seconds and 1 minute each. So this is quick, which I know for this group is going to be hard because they all like to talk. But in terms of 2025, what do you think are the things employers are going to have to be focused on in 2025? Alex, if you were to pick one thing, what would it be?
I think it's just monitoring how the changes that have been implemented in 2024 are being rolled out. So just keep an eye on it, because there's not going to be a lot of change in the IR space. It's going to be more bedding down what's there.
Okay, thanks, Alex. Sarah?
I've got 6, but I'll pick my favorite one. Increased compliance. So sponsorship breaches and compliance at an all-time high. ABF are out in force attending client sites unannounced. So get your house in order. Make sure your files and your records are up to date. And you've done a health check or audit, whatever you'd like to call it, on your temporary visa personnel, regardless of whether they're sponsored or here on a temporary visa. Please ensure you're Vivo checking them. You've got all their documentation on your electronic HR file. So if ABF do come knocking at your door, you're able to present them with that information.
So they're coming out to employers' premises more often.
Pretty much, yeah. We've had about 3 or 4 of our clients in the last 6 to 12 months confirm visits from ABF for no reason, just to come and say hi and probably scare the bejesus out of them. A couple of them did have a reason, and thankfully everything was fine and in check. And those requests could be random. They could be a disgruntled employee that calls the department's Dobbin line, and then they have to go and investigate that as well. So just have your house in order. As friendly as the ABF can be, they are there to ensure you as an employer of temporary visa holders are doing the right thing. And if you're found to not be, then there could be significant penalties from monetary to criminal and civil. So if you want to have a chat more about it, give us a shout.
Yeah, and because we've also seen unions as well contacting the department, haven't we?
They are. That's fun.
Yeah. Your turn.
Okay, just one from me. Interdisciplinary collaboration between, who is leading psychosocial. At the moment, I think that's a little bit unclear as to who's leading it, and there needs to be greater collaboration, and there's sort of some risks in things falling between the cracks in this space moving forward if someone's not leading this space within organisations.
Yeah, thank you. And Jamie?
Look, if I had to say one thing, work from home, it's causing an issue. It's pending. The clash is pending between employees and employers with their different agendas. We've seen it come through in odd ways. We've seen it with an acquisition, one organisation acquiring another, and the organisation being acquired had strong work from home allowances, close to 100%. In some cases, people actually moved states. So therefore, it became a real issue around contractual right, workplace rights. Are you changing the position? Is it a redundancy? So it's messy, but work from home is going to be something that is going to come to a head at some point.
Exactly. And I think you and I have discussed it, and we've discussed it at that conference recently about making sure you do what's right for your company, your business. Don't get caught up in the rhetoric and what's being said about others. You do what's right for your culture and your business. So thank you very much to the panelists. We're coming up to an hour and we're going to get cut off. Zoom's going to cut us off. Thank you. We will respond. We didn't get a chance to go through all the questions. We will definitely make sure if there's any questions that are sitting there waiting to be answered, that we will, someone in the team will come back to you. In 2025, we will be starting the Mapien data project. We're coming up with a nice name for it, where we'll be looking at these different subject matter expert areas and starting to collect information from employers anonymously about what they're doing in some of these areas and starting to share it, so people know, you know, what others are doing, because that's a common thing that we get asked by employers across Australia. But until then, I hope you all have an amazing finish to 2025, a great Christmas and New Year with your family and friends, and we look forward to seeing all of you again. End of 2024, not 2025. And we look forward to seeing all of you in 2025. Thanks, everyone, and thank you to the panel.
Thanks,
Thank you.
guys.
Thanks.
Bye.
Bye.